All rise. The Court of Appeals Division 1 is now in session.
Thank you. Be seated. Good morning still, right? Still losing track here. Now's the time set for oral argument in cause number 1CA CV17-0787, FAULKNER versus Laboratory Corporation of Laboratory. We're thinking about the first case right now, so you guys need to change my focus. Laboratory Corporation of America et al. For everybody's information, these proceedings are, as is usual, being both audio and video recorded, and so you will know where to go in a couple of weeks to see how you did. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And as always, Appellant, if you wish to save any of that time for rebuttal, it's up to you to do so. Let us know, but it's up to you to do so. We have reviewed the briefs, and we've conferenced the case this morning, so we are well aware of the facts and the issues attendant to this argument. Please keep that in mind when you figure out how you want to structure your argument. We do that for your interests, advise you of this for your interests, not necessarily for ours. Use your time wisely. Counsel, when you come to the podium, I would ask that you each state your name and who you represent. And with that, counsel, it's your podium.
Thank you, Your Honor. Good morning, may it please the court. I'm Rob Schmieder along with my partner Brad Lake, and we have the pleasure of representing Lisa FAULKNER. The trial court erred below in a number of ways. Number one, the trial court erred by excluding opinion testimony of Dr. Patel, a treating doctor. The trial court also erred in redacting part of a medical record of Dr. Yusupoff. The trial court then erred again in denying a new trial or an additor on the issue of damages for Lisa FAULKNER. And finally, the trial court erred in issuing Rule 68 sanctions against Lisa FAULKNER based upon the terms of the offer of judgment. What I'd like to do is I'd like to start with Dr. Patel, because I think that seems to be the most straightforward issue for this court. Dr. Patel was Lisa's treating doctor, and as the court is well aware, Rule 26, and we're dealing with Rule 26 before it was just recently amended.
Perpetually.
For the last time. But there's significance to that, because in the latest amendment, the court took away the confusion about who's an expert, who's not, and where they have to be disclosed. They made it very clear, if you're providing opinion testimony and you're not a retained expert, you do these things.
Was that unclear before? I mean, that's not a change in the law, is it?
No. Well, I think there was some uncertainty in how trial courts, if you did not disclose a treating doctor as an expert,
well,
that
the Rule 26.1 has been around since 1992.
Correct.
It's fair to say that in the latter half of this decade, the expectation is that there will be fulsome disclosures. That can't come as a surprise, just because the rules were recently amended.
No, that was my point, Your Honor. Not at all. I agree with you 100% on that.
Okay, but I thought the real issue here was that the bases for Dr. Patel's testimony were not disclosed.
Not at all. That's my precise point. My precise point was Dr. Patel was disclosed in 4 different locations in the disclosures.
Right.
Okay? And one of them included opinion or expert testimony, because for the opinions that he would arrive at during his treatment, he is able to testify about those grounds. So we disclosed the subject matter, the substance, and a summary of the grounds of his opinions.
Right.
Okay?
But there was an objection based on the lack of substantive content of your disclosure, that the bases for his opinion were not disclosed.
There was never any objection. There was a motion in limine to exclude it at trial for over 6 months. Well, it's a significant point. For 6 months, defendant never once called, questioned, asked any details about any concerns that they had. And the first time this was fronted was after discovery closed on the eve of trial, as we're heading into trial. And
so counsel, is it then appropriate under the rules? Is it necessary under the rules in order to preserve your right to object later that counsel contact you in some verifiable manner and advise you that your discovery is deficient?
Yes, and I'll for 2 reasons.
Obligation to take discovery.
Affirmatively.
To take discovery, I'm sorry.
Well, you're
there were 2
suggesting,
different questions.
No, I think they're the same question. You're suggesting that because the defense never inquired further, that Dr. Patel should be able to testify to whatever you want him to.
Not at all. To the 4 corners of our disclosure, which for Dr. Patel disclosed that he would testify about, and again, these are the subject matters, causation, treatment, prognosis of plaintiff, permanency of issues, but then specifically, we identify that the crash, that Dr. Patel would testify that the crash injured her C4-5, C5-6, L3-L4, L4-L5, L5-S1 spine, those discs at those levels. We disclosed that he was expected to testify that those injuries were caused and or aggravated or remain symptomatic by the crash.
What was the basis that you disclosed for his testimony on causation?
A summary of the grounds were it was based upon his care and treatment of the plaintiff, the treatment of the other providers whose medical records that he had, his education and experience as a doctor.
That doesn't explain why he has that opinion. You could have used that very same disclosure if you were representing the defense and putting forward an expert who came to the opposite conclusion. There's nothing in that disclosure that I see that explains why his opinion is that there was causation. Couldn't that same disclosure have been used to justify an opinion that there wasn't causation? All you've said is, this is a really smart guy who knows what went on.
No, what we've said was, here are his records that go through the whole methodology of his treatment of the plaintiff. Well, it does. I mean,
right, but that doesn't explain his causation opinion. That's the concern. Yes, he can testify, I think, as to what injuries he observed. Sure, he can testify to being a treating physician, but now you're asking him to go further and say these injuries were caused by this cause and not some other cause. There doesn't seem to be any basis for that. There seems to be foundation, but not a basis for an opinion. And those are 2 different things.
Every treating doctor who treats someone who's injured is basing it upon what they see, what the history is, and what their experience in and whether those forces can cause that.
So let's say then, just to illustrate the point, I'm involved in an accident on Monday, and then I'm involved in another accident on Tuesday.
Correct.
My treating doctor is going to testify as to causation. Which defendant caused my injuries? The treating doctor has to have some basis for saying that wasn't a pre-existing condition, that was caused by my Tuesday accident.
He did have that in his records. It said post-secondary. These injuries are secondary to the motor vehicle crash.
You didn't explain in your that was his conclusion, but there was no explanation in the disclosure as to what methodology he used to form a causation opinion. All he's saying is, I was confronted with a patient who had injuries.
So, counsel, what you're saying is the disclosure rules require 2 things. Number one, to sort of outline the general sphere in which the witness will testify, causation, etc., and then a document dump. And together, that's sufficient under the disclosure rules. Is that your position?
What I'm saying is, for a treating doctor, where this court has said the treating doctor is the principal witness for issues of damages and causation, where there's no doubt that issues of future medical care arise in personal injury. There can be no surprise to those issues. That when we have an evidentiary rule 803 paragraph 4, an exception to hearsay, that when doctors make findings in their records about the cause of the symptoms, that those are admissible before the jury, that yes, records along with that disclosure can do that. Asking
They're
more.
not hearsay. That doesn't mean you don't have to disclose.
No, well, the record itself was disclosed, but saying more, asking, and this is the trick bag that I was previewing. Asking us to say more now converts a treating doctor who formed opinions during his treatment of a patient. You now are asking us to go ask him questions, and then you start getting into, well, once you start asking doctor questions, hypotheticals, all of that, now you're converting them to an expert witness beyond just their causation opinions.
Let's step back and place this all in context.
Yeah.
At trial, the big issue was causation, right?
Correct, yeah.
Okay. The big issue wasn't were there injuries. The big issue wasn't negligence. It was causation. And we're now talking about Dr. Patel testifying on the issue of causation.
Right.
How does he know what the cause was? Because I still don't know.
He knows.
I know what his conclusion was, but I don't know what his methodology was.
Well, and again, there's nothing in the rule that says the word methodology. It says a summary of the grounds.
Okay. I don't know what the grounds were for
The
his
grounds were his
conclusion.
education, experience, and his treatment of the plaintiff, which are all disclosed.
What part of the record? When I'm looking at grounds, I want to know if he's saying this, where he's getting that from.
He,
And if you just say magically he knows because he asked her.
No. It's very clear. And when you look at the offer of proof, which completely matches the disclosure, the offer of proof, he says that when he takes a history, he looks at prior doctors' records, and those issues form his opinions on how to treat and what the cause of those injuries were, or what made them aggravated or symptomatic. That's precisely what was disclosed here.
And that's fine for a doctor to use that information to decide how to treat. That's what doctors do. When you want to use that doctor to prove that a certain injury was caused by a certain event and therefore a certain person should pay for it, though, you need some basis for the conclusion. I mean, I have a lot of education and experience too, but I don't think I could tell you what caused these injuries. And so just saying that this guy's a doctor does not give us a basis for the conclusion.
Well, we said more
education's
than
different,
we said more than that. I mean, we talked about his specific treatment of the plaintiff.
Right, but again, we're talking about one issue, and that's, did this accident cause what he was treating? How does he know?
Well,
I still don't understand the grounds for his knowledge on that.
Well, let me back up the issue a little, because the question, as the Supreme Court has said, is one of the requirements that the court must consider is what were the efforts of the other side to raise any of these deficiencies, alleged deficiencies, before you exclude the evidence. Because your opponent's not allowed to lie in wait. That's very clear about that. I mean, in Bryan, the Supreme Court kept talking about common sense about what all this means. When you look at what happened in this case, 3 months after Dr. Patel disclosure went out, the defense had hired Dr. Hartzler, a defense medical examiner, who reviewed Dr. Patel's records, formed all his causation opinions without there was no doubt ever raised by the defendant in any of this. They hired a biomechanical engineer who did the same thing. And they prepared this whole defense. And it wasn't until trial when this became an issue. Then at trial, during the offer of proof, and I invite the court to look at its transcript 467. During the offer of proof, my opponent was asked, do you have any questions? He didn't have any questions because he wasn't surprised by...
Why does the defense have to do anything?
No. Because what the defense said next was what was important, Your Honor.
Okay.
He said, no, I don't have any questions. But if this was going to go in front of the jury, I have lots of questions for cross-examination before the jury.
Okay.
Okay? So this was fairly disclosed. He wasn't surprised by anything that Dr. Patel was saying. Then we get to the future care, because we have two issues here. We have causation, we also have future care. By the way, the trial court, in her opinion, her November opinion of last year, doesn't even address causation for Dr. Patel. That wasn't the grounds for her excluding it. It was all about future care. But at trial, Mr. Stanfield specifically stipulated to future care and said he'll get there, and again, that's on 467 of the transcript. And then he said the only issue is on causation. So,
Counsel, let's talk about the medical records. Was there, you said it's sufficient under the disclosure rules to just generally outline the areas, causation, negligence, and then to provide the medical records. Was there a document in there in which the court, which the judge, where the doctor said Ms. Faulkner's injuries are attributable to this car accident, or do they reflect an injury that predated the car accident and an injury that post-dated the car accident without any definitive instruction?
I know there are at least one, but I know there are multiple ones in there. I know we cited one in our brief where the doctor, in the language, is pain secondary to motor vehicle accident. And the only motor vehicle accident that was referenced in the records was the accident at issue. So,
is that the sum total of the causation discussion in that medical records? Because you're saying we look to the medical records, right? If you want to know what the opinion is. So now I'm asking you, I'm going into those documents and I'm reading page by page for exactly what you said, which is the basis of the opinion. And you're saying there's one page that references as secondary to a motor vehicle accident, and that's the basis of the causation opinion.
No, what I'm saying is the opinion that the doctor was going to suggest to testify that it was caused or aggravated her symptoms was, I mean, it's right there in our disclosure.
Okay, so he makes that conclusion. We've been at this now for more than 15 minutes. I still don't understand the grounds for Dr. Patel's causation opinion, but if you have other issues you want to address, you
now,
might want to.
well, and Dr. Yusupov, well, then we go to Dr. Yusupov, who the court redacted a line out of his medical record that precisely said what the court just said. It's my opinion that the crash caused this. She then said, well, no, I'm going to strike that out, redact that, and not let the jury hear that. Now, that's right out of a medical record. It wasn't solicited. It wasn't asked by anyone. It was the doctor's conclusion based upon what he saw there, and she just redacted it.
Well, she didn't.
She redacted it.
She did redact it, but she didn't just redact it. You described it as though it came out of the blue. I mean, there was emotion. Let's talk about why the trial court redacted.
It was a medical record. It wasn't testimony from a doctor.
Right.
And so it was information that was timely disclosed. It was disclosed 14 days after she saw that. It was over a month before discovery ended. This is one of the problems, and I want to get to this real quickly before the trial court kept acting like this was a Rule 37C1 issue. Everything was disclosed. If it was an adequacy issue, the proper sanction is for whatever time and effort they spent to figure out what we failed to disclose, that the trial court could award attorney's fees in time under C2.
Well, under Rivers v. Solly, a proper sanction can also be dismissal of the entire action. So it seems that the court acted in a fairly measured fashion here. I believe the court's point on Dr. Yusupov's redacted sentence was that the doctor was never disclosed as an expert witness, and by reviewing records outside his own treatment necessity and coming to a conclusion about the cause for legal purposes.
There was absolutely no basis that for a finding that this doctor reviewed anything outside of for his treatment purposes. Not one shred of evidence.
How many times did she see that doctor?
She saw him for a second opinion after she saw Dr. Landsman.
How many visits?
I think it was just that one, and then he recommended a spinal cord stimulator, which Dr. Patel had been talking about in his records that that was something he could provide her.
And the expert deadline had passed. What
Deadline
she
had
saw,
passed.
right.
Yeah, absolutely.
And so your argument is any physician she saw after at whatever stage, as long as she supplements quickly whatever their opinion is, the deadlines don't matter.
No, what I'm saying is this was a medical record where a doctor made a statement about the cause of her symptoms, just like the hearsay exception provides that you can look at what doctors do, and it was disclosed timely. There's no issue that it was disclosed. It was within the discovery deadline. But it's not an expert opinion. It's a medical record. The fact that we can read from those medical records is an exception to the hearsay rule.
So it's all your whole argument is premised upon this physician opining upon causation is not an expert. The one-time visit late in the litigation was just a treating.
It was a second opinion to see whether or not she could have surgery. She wanted to have surgery. She wanted to do something to get better. She went to Dr. Landsman. He said no surgery. She went to Dr. Yusupov. He said.
So in the course of offering a second opinion, this doctor just formulates a causation opinion? I mean, that seems
It's
above and beyond the call of duty.
I would like to reserve some time, but absolutely not. I see it all the time in records. I see doctors say more likely than not, more probable than not, but I see my time is dwindling.
Good morning. I'm John Barnes here for Laboratory Corporation and Lance Esterbig. Starting with the exclusion of evidence, asking this court to find that Dr. Patel made substantive disclosures advocates the wrong standard of review. Under the abuse of discretion standard, the only question that matters is whether the trial court could have, within the bounds of reason, found that Dr. Patel's disclosure lacked substance.
How did it fail to lack substance? Define that for us.
Well, I think the court has already done a good job of defining that today and discussing with my colleague how the disclosure failed to draw any connection between the doctor's observations and the underlying accident at issue in the case.
Well, what sort of connection would you expect? From a medical standpoint, I'm not. In other words, Dr. Patel is not a biomechanical engineer, not an accident reconstructionist. He's a doctor. He's got a patient who was just in an auto accident. The patient has injuries consistent with an auto accident. What would you expect him to say in a disclosure?
I would expect, and I think the trial judge also articulated this, I would expect something beyond just labels or conclusory assertions. I would expect some sort of
Example. Give me a hypothetical.
Well,
I'm
not a doctor, but
but you're a lawyer and you've seen disclosures before. So give me an example of a good one.
Yeah, something like this is typical of what I see in my patients who have car accidents or something along those lines. Something that makes the connection between the accident and the injury.
So is that what was deficient? Because again, we have a page now in this stack of medical records in which Patel does say injuries are attributable to accident. Okay, there's a page now apparently. I'll ask for a citation to the record. You're saying you need more than that.
Well, so two things, I guess. First, I disagree. That's not in the record. The medical record I think my colleague is referring to is the subjective part of the SOAP note that the doctor produced. And so just because the patient says, I had this accident and this is the result, that's not the doctor's conclusion.
Is that what we're going to be finding at that citation?
Right.
I was told by the client that she'd never had an accident before. This was it. This was
Well,
the only one.
it's under the subjective part of their headings, so it's subjective, objective, etc. And this is the part where the doctor is describing what the patient described to him. And I had a second point, but I think it just sort of dovetails with Judge Swan's question, and that is there has to be some sort of rational explanation connecting causation here, and that's utterly lacking. It's just conclusory statements. The doctor, reading the disclosure, it's not even clear to me that the doctor is going to say the accident caused the accident. The accident caused the injury. He just says, I'll testify about causation. I think that the trial judge was well within reason in finding that that's not sufficiently substantive to satisfy the disclosure rule.
So let's assume that that the plaintiff's counsel is correct, and there is a document in which Patel says we have a car accident that has caused injury, and then just moves on to the injury and how we're going to treat it. What more are you looking for, or would you argue is required to meet the requirements of a disclosure, an adequate disclosure?
Something beyond just a conclusory statement like that. Something that draws...
How about the statement, these injuries are consistent with trauma, and trauma can be sustained in an auto accident? Would that have changed the overall makeup of this case?
Well, that's
that simple sentence that would not come as a surprise to you for 1 second, would that have legally changed the result?
That's sort of what I was trying to articulate answering your question before, that if the doctor had elaborated on, I have experience treating patients from car accidents, and I see this all the time. This is typical of what...
I'm not saying that. I'm saying, let's say the doctor isn't really somebody who treats accident patients a lot, but the doctor says, I notice there are some significant injuries to this plaintiff. They are consistent with trauma. Plaintiff reports she was just in an auto accident. That is suggestive of causation to me. Would that have saved the disclosure?
I don't have any kind of investigative mind.
No,
but I think
I'm just asking you a question. As a matter of law, would that have saved the disclosure?
Right. So if a patient, I'm a doctor and a patient comes to me, I would at least try and rule out other explanations. Does she have a history of these?
I'm not getting an answer. Would that have saved the disclosure?
I think if there was some additional substance, something drawing the connection.
I just gave you the additional substance. Would that have been enough?
Well, we would have argued about it because it's the trial judge's discretion.
So it might have been enough?
Well, the trial judge, I think, still would have had
because if it might have
reason.
been enough, then it seems to me maybe a bit harsh to say that the rules require you to state the obvious.
Maybe the disconnect between us, Judge, is I feel like we're sort of talking about this in a vacuum. If we had a comparison, maybe, and I cited to the Solemino v. Yonan case in my answering brief, and that decision, I think it's paragraph 15, quoted verbatim the disclosure that the court found to be inadequate in that case, and it's strikingly similar to the one here. It says basically, doctor will testify about causation. He'll testify about the medical records, and essentially that was the gist of it. And
Is that how you would define the disclosure here?
I think the two are analogous to the point where the trial judge had discretion to find a lack of substance.
And here, if the doctor had said, accidents can cause orthopedic injuries, this patient was in an accident and has orthopedic injuries, therefore there is an inference that the accident caused the injury, is that adequate?
The reason I'm struggling to answer your question, Judge, is because that's not what we have here, and I don't know.
That's what we do in appellate arguments. We ask hypothetical questions. So indulge me.
Right.
Is my hypothetical adequate?
I would have argued to the trial judge, no, that's still not adequate. There has to be...
Because?
I assume that means you're arguing that to this panel now.
That's a good assumption, Judge.
Okay.
Yeah.
So
Good
why is that
tactic,
not
too.
adequate?
Is it good tactic to...
Consistency.
It's not adequate because it's so conclusory. It's so minimal. It's very minimalist, and it really doesn't give me anything to
more
anticipate.
Baroque.
I want something that will allow me to anticipate what the witness is going to say when I depose him.
Well, let's talk about that. As an attorney, you have different tools in your toolbox, your discovery toolbox. Is that correct?
Right,
You can take
yeah.
a deposition. You can tender interrogatories. Why aren't those the proper tools to flesh out and color what is otherwise disclosed, not as robust as you might like, but why don't we at least say, counsel, look to your toolbox, and that's where you'll find your color?
So glad you asked that, Judge, because it dovetails with my next point, which goes to the whole lying and weight argument that my colleague made. Defendants did not do nothing here. They sent discovery requests, and they specifically asked about future care, and they specifically asked about causation expert testimony. Now, plaintiff didn't provide any substantive response to those interrogatories, and she didn't supplement her responses.
Well, let's talk about that. Was there a uniform or non-uniform interrogatory that was tendered that would have required more and more detail as it was, I guess, the opinions were formed? So what we're saying now is outside of the rule, Rule 26.1, you also have these freestanding interrogatories that don't just, it's not one moment in time that they're answered, that there's a continuing obligation to answer. Were there any interrogatories outstanding that asked the other side to explain in greater detail precisely what their causation argument is?
Well, not in those words, Judge, but there was a request for information about expert witnesses who would testify about causation, and it went unanswered.
And what did it ask for? Identity? Name?
I misspoke. It didn't go unanswered. It was not a substantive response. So, I mean,
What was the nature of the request? It was an interrogatory?
I don't have it in front of me, but I think it was an interrogatory, and it said.
Oh, if it was an interrogatory, how do you know that the response wasn't substantive?
Well, I have it. It's a discovery request asking the party to identify their expert witnesses, what he will say about causation, etc. So, I mean, that's in the record. I cited it in the brief.
Counsel, did you ever ask opposing counsel in any form if, given the fact that this was an automobile accident and there was indicia of her being harmed in an automobile accident, she'd ever been harmed in an automobile accident before?
It wasn't phrased that way, Judge. No.
How was it phrased?
It was more general in the sense, identify your expert witnesses and tell us what they're going to say about causation. Essentially, that's the gist of what the request was. And if I could just step back from this lying in wait issue, this is but one factor articulated in the Allstate case where the Supreme Court discussed good cause. And Lisa Faulkner failed to address any of the other factors. So not only is the good cause issue, I think, waived based on her failure to completely address it, but she failed, at the end of the day, she failed to confront the more important fact, which is that these other factors, and I discussed them in the briefing, show that the trial judge had more than an adequate basis to find a lack of good cause for the substantive, the missing substantive component of the disclosure we're talking about. So I'm more than halfway through my time. Unless there are any questions on this issue, I want to make sure we.
I tracked down in your brief here the discussion of these interrogatories, and you mentioned two. And the first says, will you incur medical expenses in the future? Mm-hmm. All right, so that wasn't the causation one?
Right. There were two motions in limine. That was the first one.
So let's go to the second one, which says, do you know of any person who is skilled in a particular field or science whom you may call on any issue? Mm-hmm. So is that the causation one?
That's what I'm talking about, Judge, yeah.
Okay, so that they had to say, you know what we do? It's this physician, and given that, here's the basis of the opinion.
Correct.
It seems that we're pretty far from the notion that you asked an interrogatory about causation that went unanswered.
And I mean,
there's no interrogatory about causation, and there was an answer.
Yeah, I misspoke about going unanswered. I meant substantively.
It seems that there was a misspeaking about the interrogatory about causation.
Well, we asked about any issue, and the doctors are going to talk about causation, or they're going to talk about future care.
If I sat here and asked you, discuss any issue with me, and then faulted you for not raising the one that happened to interest me, that wouldn't be fair, right?
That wouldn't be fair, but look, if I can just emphasize this point, that we're talking about one out of the 5 good cause factors, And even if that one factor, this court's willing to find that it doesn't bode well for me, there's still 4 other factors out there that are relevant. And the case law says we have to consider good cause in like the totality of these factors. And there was no response in the briefing about the other good cause factors. So
Can you jump to the trial court asking in advance of trial plaintiff's counsel for certain records, and they weren't provided until 3 days into the trial? Is that accurate?
that sounds right, Judge.
Explain the relevance of that. How does that figure into your argument?
Well, so it goes to the harmless component of, I think it's Rule 37. So if it was a harmless failure of disclosure, then no harm, no foul, right? But the court articulated several failures along the way in the disclosure and discovery process in this case. And I'd point to the Marquez case where that was significant. The counsel had demonstrated several failures. And you have a question.
But let me try to focus here. Was this causation based? Was the court saying give me the medical records on causation?
The motion at issue was a motion in limine excluding the causation opinions. Yes. So the judge said, well, I can't rule on this motion until I see what the doctor is going to say. I don't see it in the disclosure.
So we're talking about that stack of documents. And so the court was saying, could you go through that stack and pull the pages that set forth the opinion? Is that?
As I recall, that's what the judge wanted. She said, show me the records that support.
And that wasn't provided until three days into trial.
Well into trial is when it was handed to the judge, is what the transcript shows, Judge.
How many documents are we talking about from Patel, medical records?
I don't know offhand. It was a trial exhibit, and we cited it. We talked about it in the briefing.
It or they?
It
implies one.
As I recall, the trial exhibit was several documents. So, does that answer your question, Judge? I feel like I wasn't very helpful with that one.
How would you have been prejudiced if, at that 3-day mark, the court had said, sure, bring them in? What was your situation?
Well, we would have been blindly cross-examining the witness without
Witnesses had already been put on?
I can't remember if Dr. Patel had been put on at that point or not. But the point is, the case law says trial doesn't even have to be set for this court to affirm an exclusion. And here we are halfway through the trial. So, I mean, if to the extent that's a factor, I think it supports the trial court's ruling here.
We've had an interesting debate here for nearly 40 minutes about disclosure and its impact on the trial court's decision to admit evidence. If the trial court had admitted all of the evidence in contention today, would you say that would have been an abuse of discretion?
If the trial court had admitted all of the evidence?
Yeah. If there had been no exclusions at all and the trial court just said the door's open, Dr. Patel, all the doctors, just come on in and testify to your heart's content, would that have been an abuse of discretion?
I honestly don't know, Judge. I think we have to look at whether the trial court has a reason for the decisions it makes. And if the judge, without any input from the parties, without any documents in front of it, just says, whatever, have at it, do what you want, I think that would be an abuse of discretion, yeah. But what we're talking about is a considered...
If the trial court had considered, as we are today, all of the arguments that we've heard and simply made a different decision after careful consideration of everything we've heard over the last nearly 40 minutes, would that have been an abuse of discretion?
That's how the abuse of discretion standard works. I think if...
you mean no, that wouldn't have been an abuse of discretion? Because the standard contains such latitude? Is that what you mean by that's how it works?
Right. If there's something if the judge can point to something that supports his or her decision, then there's it's within the realm of reason, and that's how the cases describe the abuse of discretion standard. The trial judge must act within the realm of reason.
So you took a calculated risk in not deposing Dr. Patel. You didn't depose her, is that right? Or him, I'm sorry.
No, there was no deposition of Dr. Patel.
There were, okay, not passive voice. You didn't depose him?
I did not depose him, no.
Okay. So you had a disclosure in this stack of documents, but you make an affirmative strategic decision not to depose. Is that premised upon, did you just not know that they might, this Patel might go into causation, or what was your thought process on not deposing Dr. Patel, who had been disclosed as a witness?
Judge, I can't think of anything in the record that would give me a basis to answer that question.
How many medical witnesses did they present? How many were scheduled to appear?
I would have to look again at the disclosure statement.
Are we talking about 3 or are we talking about 13?
It was not 13 as I recall, but it was more than one. So.
And is it your typical practice not to depose medical experts who are going to get on the stand and say something? Because I certainly have seen it the other way, where the medical experts are key to the issue of what your witnesses are going to need to say, aren't they? Knowing what their witnesses are going to say is what you're going to prep your witnesses based on, isn't it?
I see your point, Judge.
Good.
But that ignores the disclosure obligations of the party we're talking about here.
Hey, but I already asked you about what prejudice would have occurred if the judge had just straight up accepted it. Now I'm asking you the other side of it. And you didn't depose them. You had the opportunity to depose them. You clearly knew before the trial that they were potentially going to appear. I've certainly seen cases where medical witnesses were asked, are you expecting to provide expert testimony on the issue of causation at this? And you could lock them down by that. When they said no, you knew it was a recent creation or fabrication or whatever you want to call it if they got up and started doing that. But you didn't do it here.
That may well be true, but I would point the court to Marquez v. Ortega, where none of that happened either. But there was still this failure on the part of the disclosing party to adhere to their obligations under the rules, and those rules have to mean something.
Okay, so it's strictly rule controlled. This whole issue comes down to one question, and that is, did the court properly apply a rule, as opposed to whether or not you had done what you needed to do to try and avoid the dilemma we're sitting here talking about today?
What it comes down to is whether the judge applied the rule within her discretion, and based on the factors we've been talking about here today, I think it's clear she was well within the realm of reason to find that the disclosure was not substantive and that there was no good cause for that failure to make a substantive disclosure.
Thank you.
Thank you.
I will speak very fast. It's Exhibit 53 at Bates 1013 is where you'll see that in the records. Post secondary to Payne secondary.
See that in the records.
See that? See the language that you were asking me for the cite to. The Payne is secondary to the motor vehicle accident. It's Exhibit 53 at Bates 1013.
And that's the sum total of discussion.
That's the one where he specifically says it. There's other references to there being an accident. That's where he says Payne secondary or due to.
That's what makes your disclosure sufficient.
I think my disclosure is sufficient as it is, but I think that also,
you said that this stack of documents was absolutely essential to, I mean, you had your description, and then you had the documents. Are we now saying you didn't even need the documents?
No, yeah. What I'm saying is that any further questions that they had were there in the documents, or they could have called me, like they were required to under Allstate to inquire about any insufficiency. But yes, I think that is the citation that you were asking for. As far as the 5 factors, I've addressed them all. There was no failure. There's an argument that it was insufficient, which is a different issue. The willfulness of the conduct. There's no evidence that somehow we were trying to hide this information. We were trying to provide full disclosure. The prejudice has to be assessed on both sides. There's great prejudice to the plaintiff, there was no prejudice. He couldn't even articulate one thing that would have prejudiced them in their case, and it certainly didn't prejudice their preparation. There were no efforts to resolve this dispute, and the overall diligence in prosecution. We were producing documents. We were making disclosures. We were doing all that. There was nothing in the record. The court made one reference, and I know I can't remember who made the reference to the court saying that, well, you expect me to look this over 3 days into trial. We provided the full records. The court then asked us, go through, pull out the records before Dr. Patel, enough time for Dr. Patel to testify. We then did that. The court made that comment. I misunderstood exactly when the court wanted that, but that's in trial. She'd already made the decision to bar it, and we were asking her to revisit that issue. The other thing I'd like to note is
Go ahead and finish this thought.
Because this is important. He keeps saying that all we said was the doctor would give an opinion about causation. We say Dr. Patel is expected to opine that these injuries and or conditions referenced above, where it identifies all the various levels, caused and or made symptomatic, or were caused and or made symptomatic by the motor vehicle accident of November 6, 2013. It's very clear. It's not just he's going to testify about causation. It's about what his opinion is that it caused it.
Counsel.
Thank you very
We're
much.
out of time, and I think we got some other folks here that would like to hear another argument.
I appreciate all your time.
Thank you.
Thank you.
We're going to take the matter under advisement at this time. We will certainly rule in due course as to this matter. We adjourn.